Welcome and good afternoon. My name is Lisa Ramirez. I'm founding partner of U.S. Immigration Law Group. I am a California State Bar Immigration and Nationality Law Specialist and one of the first women and the first Spanish speaker specialists in the County of Orange. It is my pleasure to spend this next hour with you today to educate you on DACA, the current reality of DACA. We'll discuss the Supreme Court decision and as well as the future of DACA. And I know that there's a tremendous amount of anxiety and worry, especially from DACA recipients. We are in very uncertain times, but my commitment is to leave all of you more educated, equipped, and empowered, and hopefully hopeful regarding your future. I know we have people from all over the country participating in this webinar, which is really exciting for us. We have DACA recipients as well as many colleges, universities, faculty, administrators joining us as well. So welcome to all of you. I do have a tremendous amount of information that I would like to cover, but I want to start with a couple of housekeeping points. One is I am going to do my best to share the key points and most important aspects of the presentation. You will find that the slides do have additional details, which I included deliberately because you will be able to access the copy of the PowerPoint both during this presentation and afterwards. We'll send a link to the webinar recording that you can share with others as well. You do have access to both the PowerPoint slides and a one-page handout, and both can be found in the Handouts tab on your toolbar. So if you can access this information there now, and most importantly is that you will have an opportunity to engage with me and ask questions during the presentation, and I will do my best to answer them either as we go or at the end of the presentation. So without further ado, let's go ahead and get started. Okay, so I want to talk very briefly about what is DACA. So those of you who are DACA recipients are clearly aware that DACA is deferred action. Deferred action is not something new. Deferred action has existed for a number of years in a variety of different circumstances. It strictly provides the temporary protection from deportation and work authorization. It is not legal status. It is not a step in the direction of legal status. It doesn't enable anyone to pursue legal permanent residency or U.S. citizenship. However, DACA was very valuable and continues to be valuable because it provided a valuable way for people to travel and obtain a legal entry. Unfortunately, advanced parole, which is the means through which individuals were able to travel for humanitarian or educational or work reasons, is no longer available, but nonetheless, that benefit has served many recipients tremendously because it's enabled them to be able to adjust status when they've married U.S. citizens or been able to adjust through family-based petitions. The other really important aspect of DACA that is important for everyone to be aware of is that it prevents the accumulation of unlawful presence. And that's really important because individuals that have received DACA before turning 18 essentially never accumulated unlawful presence, which means that they would be free to continue an immigration process, go abroad through the consular process to obtain an immigrant visa without triggering any of the unlawful presence bars that are a part of our laws. DACA, like I said, is not legal status. However, it also does not pardon any other immigration violations and unlawful entries into the United States. So again, it's not forgiveness or pardon for a variety of immigration violations. So what is the current status of DACA? I think most of you are probably aware that there's no initial applications being accepted. And that's problematic for a number of reasons. This entering, graduating high school students and first-year college students are essentially the first pre-DACA students that we're now seeing entering our higher education institutions. That means that they were too young at the time that DACA was terminated to be able to apply for DACA. And so they're essentially undocumented, and it is very difficult for them to be able to access employment, financial aid, and other benefits that some of our DACA recipients would be able to access because they have a Social Security number. So again, many of these students are basically the population that we had seen before DACA even existed, and so this is kind of the first incoming class of undocumented students that didn't have DACA as an option. So right now, DACA recipients can file a renewal application to renew their work authorization and their DACA status within 150 days of the expiration date of their work permit. Now, previously, before DACA was terminated in terms of the initial applications, USCIS, U.S. Citizenship and Immigration Services, had a very strict hardline rule that applications submitted for renewal beyond the 150 days would not be accepted. We are not seeing that same approach. So some of our clients have been very successful in renewing beyond the 150-day period, but we have heard of 2 cases nationally that were rejected because they did not file within that 150-day period. So based on our conversation at the end, and I'm sure there'll be some questions we can talk more about in terms of whether renewal should be filed now or whether we need to wait to fall within that 150-day period. Ultimately, we know Congress is the only one that can pass legislation to create a permanent fix. And we are going to talk about some pending legislation that I really encourage everyone here to participate and engage their Congress people on. I do want to also kind of bring to everyone's attention that earlier this week, USCIS did publish a proposed rule in the Federal Register that will increase a number of immigration application fees. The I-821D form, which is the renewal application form that never had a fee associated with it, now will have a fee once this fee increase is finalized. So DACA applications now will cost an additional $275, which is separate and apart from the $495 that is already paid as a part of the renewal process for work authorization. And that application, the Form I-765, will also increase by $80. So there's a significant financial impact should DACA continue to exist that will affect our recipients in the future. So I want to talk very briefly about litigation. So prior to the cases that the Supreme Court currently considered earlier this week, there were other types of litigation challenging the validity of DACA. So these cases really involved, this one particular case, Texas versus Nielsen, involved 6 states suing on the lawfulness of DACA, meaning their whole approach was DACA should not have existed to begin with. They attempted to request a preliminary injunction to basically halt DACA. The federal government declined to defend DACA. There were some DACA recipients and the state of New Jersey who intervened to defend DACA. And although that case has not been resolved, there was the preliminary injunction was denied, which is what has allowed DACA applications continuing to be accepted by the government for renewal purposes. And the judge in that case, it was actually the same judge who heard the case regarding DAPA, which was, some of you may remember, the Deferred Action for Parents of Americans and Lawful Permanent Residents, and was going to expand DACA. But the same judge did, in fact, issue an injunction back in 2015, halting both the expansion and the DAPA program. But I thought it was interesting just to share with you some of the language that was actually included in his order denying the plaintiff's request for a preliminary injunction. And that was that it's impossible now with respect to DACA to, quote, put the toothpaste back in the tube or unscramble the egg. And I share that with you because I think it's really important that many people in the general public, our judges, legislators, I think really understand that there's a significant impact on a significant number of people in trying to redact DACA or terminate DACA. A commitment was made, a promise was made, work authorization has been obtained for so many. Many have relied on the existence of DACA and continuing their education. obtaining loans to finance their higher education. And now with the potential elimination of DACA or termination of DACA, it's going to leave many individuals in a very precarious and dire situation. As far as where this case stands, Texas did not, and the other states involved did not appeal the decision. A trial date was set for litigation. However, I think everything is on hold until the Supreme Court issues its decision on the pending legislation before that court. So as of right now, the other injunctions that were put into place in terms of halting DACA altogether remain in effect, so that's the reason why USCIS is required to continue accepting and adjudicating DACA renewal applications. Now, the cases that are before the Supreme Court aren't really questioning or challenging the lawfulness of DACA. It's really addressing and challenging the termination of DACA. So the Department of Justice did something pretty extraordinary. I think the first step it took was on November 6th in 2018, that it basically asked the Supreme Court to take up the Regents of the University of California versus Department of Homeland Security case that was pending before the Ninth Circuit, to take that case up early before the Ninth Circuit would have an opportunity to issue a decision on it. 2 days later, we know that the Ninth Circuit issued a decision affirming the lawfulness of the preliminary injunction. And so that basically went into effect extremely quickly, 2 days after the Department of Justice tried to get the Supreme Court to step in. Nonetheless, the Supreme Court did agree, and the Department of Justice did request to have all of 3 cases basically challenging DACA's termination taken up. And the names of those cases are there on your PowerPoint slide. On June earlier this year, the Supreme Court agreed to hear these cases. They consolidated them. And Tuesday of this week, oral arguments were heard. And now we're simply waiting a decision. We don't know exactly when a decision is going to be issued. Typically, the Supreme Court session goes through June. Sometimes it's gone into July. So we do anticipate a decision no later than June 2020. But again, it can really take place anytime now. So I want to talk very specifically about the possible outcomes of the Supreme Court decision. So again, the Supreme Court is really focusing on 3 issues related to DACA. So the first issue is really about whether or not the courts have the legal authority to even review the Trump administration's decision to terminate DACA. Like, is this something that's even within their legal power, right? So that's kind of their first question that they're going to have to hash out. Now, if they determine that it is not in their legal power to be able to review them, that basically no decision will just reinforce or affirm the status quo, which means that the injunctions that the courts have issued to allow people to continue to renew their DACA applications would not be legally valid, because the Supreme Court would essentially be saying, not only do they not have the legal authority to review, no court has the legal authority to review these executive orders. And so that would essentially leave it to the Trump administration to determine exactly what the future of DACA will hold, how they're going to effectively terminate DACA. So they could end DACA immediately and perhaps retract or revoke any existing work authorizations. They could allow individuals to simply continue to use their work authorizations until they're expired. So the bottom line is if the court decides that the courts do not have legal authority to review the Trump administration decision to terminate DACA, we're basically going to see the end of DACA. So that's potential outcome number 1. The second issue with regards that the court is addressing is that whether the Trump administration, so let's assume the courts agree they do have the legal authority to now review the Trump administration's decision to terminate DACA. Now it's a question of whether or not the Trump administration's decision to terminate DACA was lawful or not. And so if the court concludes that the Trump administration's termination of DACA is lawful, we're essentially also back in that boat in terms of this will likely be the end of DACA. And again, the Trump administration will determine exactly how to end DACA. Again, whether to continue to process DACA renewal applications that are pending, right? Because people are renewing their applications daily. So those that already have their applications in the queue, will they allow those applications to be completed and adjudicated and those work permits issued? Or are they going to essentially end it immediately, attempt to recall work permits and the DACA protections that have not yet expired? If the court concludes that DACA itself is unlawful, so that's kind of like the third issue. So we've got, again, whether it has the authority to review. The second issue is whether or not the Trump's decision to terminate DACA is lawful. Then there's also the underlying question as to whether the existence of the DACA program itself is lawful or not. And again, same result. If the court concludes that DACA, the program in itself, is an unlawful program, then of course there will be absolutely no possibility that new first-time DACA applications will be accepted. The government must stop and will have to stop accepting DACA renewal applications. There's no discretion. There's no kind of gray area. And then also the question remains is whether the work permits issued to DACA recipients would continue to remain valid, those that have already had their cases adjudicated. But that will really depend on the reading of the court's decision, or I should say the analysis of the decision, how the court reasons and how the administration reacts to the court's decision and whether it's going to be retroactive. So that's potential outcome number 2. Potential outcome number 3 could be that the court concludes that, yes, it does have the authority to review the administration's decision to terminate DACA, and it rules that the termination is unlawful. So what that could mean is it reverts us back to where we were on September 4th, 2017, which is the day before the government announced the termination of DACA. So this is when renewals, people could continue to apply for the first time, and advanced parole were all available. We don't know exactly, excuse me, the extent to which the court's decision will allow for all of those benefits to exist, and we don't know exactly who will be eligible to apply. So the details in terms of if we're reverted back to pre-termination, we still have to wait and see exactly what the extent and parameters will be for those benefits. Now, I think a really big unknown that really I don't know anyone that would have the answer to is what this administration's response is going to be the court's ruling. The administration could potentially try again to end DACA based on different legal reasoning. I think Trump has tweeted various times, and it hasn't been quite consistent in terms of his support for DACA recipients. I think his latest tweet involved basically saying, let's wait till the court's decision, and he will work with Democrats or Congress to create some sort of permanent fix should DACA be deemed unlawful. So those are essentially the 3 potential outcomes as best as I can ascertain from the oral arguments on Tuesday. Again, I know this doesn't really probably spell out or give the security that a lot of people may be looking for and needing right now, but at least we kind of have an idea of what the issues are at stake and the potential outcomes depending on which direction the Supreme Court lands. Okay, so I don't want to leave you on a note that is less than hopeful. I think it's really important with all the organizing and activism of our young people around DACA across the country. It's been pretty incredible and inspiring, some of the actions that have been taking place recently. But I really, really want to educate all of you on some pretty critical pieces of pending legislation, because I think it's really important that we're not putting all our eggs in one basket. DACA is not a great solution. It is not intended as a permanent solution. I think it gave many benefits and opportunities for the recipients. However, we really need to look at legalization. We need a longer term permanent fix for the individuals who would otherwise qualify for DACA. And that's what we're going to talk about next. So don't lose hope on DACA. And even if DACA goes away, I really, really encourage everyone to take that energy and really focus on advocating for these pieces of legislation. Okay, so the three pieces of legislation, we've got two DREAM Acts of 2019. We have the Senate Bill 874, and we have the HR 2820, DREAM Act of 2019. In addition, we also have HR 6, which is the American Dream and Promise Act. This bill did, in fact, pass the House on June 4th, so it is currently pending in the Senate. But all three of these pieces of legislation speak specifically to Dreamers. The American Dream and Promise Act even goes beyond Dreamers to include recipients of temporary protected status and deferred enforced departure or DAD program. But it's really important that all of you are aware of these pieces of legislation that, again, remain pending. And if we want to see a better fix than DACA, then we really need to start engaging and participating in communicating with our legislators. Now, before I go any further, I thought it would be interesting for us to be able to take a quick poll. So you should be able to see, let's see here. All right, so I just kind of want to get a feel for the audience. So the first question is, in your opinion, should the Supreme Court have authority over a president's executive order? Okay, we have no votes yet. Okay, we got a couple of no votes. All right, so it looks about 89%, 90% for rounding believe that the Supreme Court should have authority, and about 13% say no. All right, let me ask you one other thing. In your opinion, will the Supreme Court decision either deem the termination of DACA lawful or deem the termination of DACA unlawful? All right, so it looks like there's a little bit more of a split, but I think it's interesting to be able to see in terms of the perspectives, right, of those of you that are participating in this webinar in terms of where you think things may stand and land. I wish I had a crystal ball to know for certain one way or another, but I think it's really unpredictable, and I think either side of this issue could be correct. I think we really don't know if they will deem it lawful or not at this point. All right. So I know, again, that there's been a lot of energy, there's been a lot of time on DACA and pushing for DACA and the existence of DACA. And I think my request really would be that we take that energy and take those activities and really try to redirect it and focus. I think it's difficult for us to have the same kind of influence on our Supreme Court or on our courts just in general. In terms of the public activism, I think that's far more effective when we're trying to impact public opinion or congressional representatives. But I really do believe that this is the time for us to really be active and engage as with regards to legislation. So I want to share with you a little bit on what's on the horizon in hopes that you won't lose hope and can dedicate some time and energy towards these pieces of legislation. Now, I'm just going to start off by saying that both DREAM Acts and the American Dream and Promise Act are very, very similar. So there's going to be a lot of details on the PowerPoint slides that kind of outlines the specificities of each of the programs. However, I'm going to talk about them kind of generally speaking in the interest of time, because I wanted to make sure that we get through all of the content of the presentation and have time for questions and answers. So the DREAM Act of 2019, the Senate version, essentially it protects what we call our dreamers. And I know that's kind of a politically charged word for some people, and they don't like to be called dreamers. I'm just kind of using that language as it's been described in the Senate bill. But it would essentially allow 700,000 DACA recipients and at least another 1.4 million eligible dreamers brought to the Americas as children to stay in the U.S. So these include the individuals that either may have lost DACA, people who are too afraid to renew their DACA. It could include the people that are entering freshmen in our colleges and universities that never were eligible for DACA. And that number just continues to grow. So this is going to essentially create a permanent fix for that population, right? So this is not an amnesty. This is not going to help, the older generation or parents of the DACA recipients. It's strictly for those who would otherwise be eligible for what we know as DACA. Essentially what it does, it creates a conditional permanent resident status that could be valid for up to 8 years. The beauty of this legislation is that those individuals who already have DACA will automatically be granted conditional permanent residence. And you'll see in just a moment that the requirements for the conditional permanent resident status is essentially the same as qualifying for DACA. So rather than having to go through that application process for conditional permanent residence, DACA recipients will automatically be granted conditional permanent residence. So it's very, very significant. However, those with or without DACA, anyone in the conditional permanent resident status, if they commit a serious crime or fail to meet the requirements set in the bill at any point in time, could lose their conditional permanent resident status. Okay, so the conditional permanent resident status, again, is not something permanent. I would even argue our permanent resident status is not even something permanent, because it is still a privilege, and anyone, even with permanent residency, can still be removed from the United States. But anyway, it's a step in the direction of permanent residency, and it's a step in the direction of U.S. citizenship. The other important fact to keep in mind is, Congress and different, legislators had talked about early on the possibility of creating like a alternative residency for DACA recipients or for dreamers that would somehow be different, because they really wanted to avoid any sort of chain migration where they would basically be treated like any other permanent resident and be able to apply for U.S. citizenship in the future and then be able to petition their family members. That is not on the table with any of these pieces of legislation. The conditional residence, the permanent residence that's being discussed and that's being offered would be the exact same permanent resident as anyone else with a green card. So what are the requirements? So in order to qualify for the conditional residence, one of the unique, or the minor differences, I should say, between the DREAM Act and the American Dream and Promise Act is the DREAM Act says the person needs to come to the U.S. at the age of 17 or younger. The American Dream and Promise Act indicates it's 18 or younger. So 17 or 18, eventually Congress will have to somehow consolidate the various bills or hash out the specific details. So we don't know exactly what the requirements will be until the law is passed. So I'm just sharing with you kind of what the proposed requirements are under the legislation as it stands. So in addition to having to enter the U.S. before the age of 17, they have to demonstrate that the applicant has to demonstrate that they continuously lived in the United States for at least 4 years prior to the bill's enactment. And this is what I share with every college student that I go and speak to at their community college or universities or other higher learning institutions, is that the bill has not been enacted. Therefore, it's really important that DACA recipients or anyone who would qualify for the DREAM Act or the American Dream and Promise Act begin documenting their physical presence in the United States now, right? So from this point forward, because we don't know exactly when the bill is going to be enacted, and you want to make sure, at least starting now and going 4 years back, you have sufficient documentation to establish your continuance presence in the United States. And again, that can involve your transcripts, if you're registered for school, paycheck stubs, medical records, any documentation with your name, your identifying information that can establish that you were physically present in the United States is going to be extremely important to have gathered and submitted. They also need to demonstrate good moral character with no felony or multiple misdemeanor convictions. We know that that's already a requirement for DACA. So again, if you have DACA and you have not committed any crimes since last renewing DACA, then again, you should automatically qualify. But good moral character is going to be a factor for conditional residence. The applicant will have to submit biometric and biographic data. They'll undergo a biometric exam and a medical exam. And they have to have been admitted to a college or university, have earned a high school diploma, or, okay, this is an or, are in the process of earning a high school diploma or an equivalent. So I can't emphasize enough the importance of going back to school for those that may otherwise qualify, that don't have their GED or did not graduate from high school, and for those to continue to study and to pursue their higher education for purposes of their life, but also for this legalization opportunity. And we also know that there's going to be an application fee. Again, we don't know how much that's going to be. So the conditional permanent residency status, once that's been established, the person then can apply for lawful permanent residency. And they don't need to wait 8 years. So the conditional permanent residency is going to be valid for 8 years. That doesn't mean you have to wait 8 years to apply for the permanent residency. So if you're a DACA recipient and you already met the qualifications for conditional permanent residency and you already meet the qualifications for the permanent residency, then there's no reason to wait. You should immediately apply for lawful permanent residency. So again, you just need to be able to establish that you've maintained continuous residence in the U.S. And there's 3 different tracks that is part of the requirement for permanent residency. There's an education track, a military track, or an employment track. And it just essentially means that you have to have completed at least 2 years of a bachelor's or higher degree program in the U.S., or that you've graduated. If you're trying to go the military track, that you've completed at least 2 years of honorable military service, which leads me to believe, and again, I don't know this for certain, but it leads me to believe that individuals in conditional residency status will be able to enlist in our U.S. Armed Forces. So that's the only kind of way I can make sense of this potential way of satisfying this requirement. Or you have to have worked for a period totaling at least 3 years. So again, if you're already a DACA recipient, you already qualify for the conditional residence, your focus right now then is going to be graduating or at least completing 2 years of a bachelor's or higher degree program. You're not eligible to enlist in the service right now, so you can't really do a whole lot about that. But if you've already worked for a period of 3 years, you're going to want to make sure that you're keeping evidence of that documentation, your paycheck stubs. Now, people ask tax returns, will that be sufficient? Generally speaking, the federal government doesn't like to accept tax returns for purposes of establishing the amount of time someone has worked in the U.S. because your tax returns just indicate how much you earn, and there's no way for the federal government to know whether that was earned within a 3-month period or a 12-month period. So you're going to want to have some other type of record keeping to demonstrate that you've been working for at least 3 years to qualify under the worker track. Now, the other component that's also present in both pieces of legislation is that the individual, the applicant, right, who already has conditional permanent resident and wants to apply for permanent residency needs to demonstrate their ability to read, write, and speak English and have a basic understanding of American history, principles, and form of government. So this we already know is something that's required for people to apply for U.S. citizenship, individuals that want to naturalize. Again, the legislation doesn't speak as to the how these things are going to be demonstrated. My guess is it's going to be in some sort of an interview exam process as we do for naturalization. And I don't know if it will be the same exam, a different exam, but nonetheless, if anyone is not fluent in the English language, it would be really important not to wait, to start now, to ensure that their ability to read, write, and speak English. And if they were not educated here, did not graduate from high school, obviously those basic steps need to be taken, but any effort that can be made to learn civics, American history, things of that nature will be really important. And again, they'll need to continue to demonstrate good moral character. Just check in to see if there's any questions. Okay, let me hold off on some of these questions. Okay. Now, the American Dream and Promise Act, like I said before, is very, very similar to the DREAM Act. I'm not going to go into a tremendous amount of detail because, again, it has both the conditional residence and the permanent residence, the 3 separate tracks. But I will mention that there are some very unique distinctions about the American Dream and Promise Act that is worth discussing. One, that it will help the 300,000 temporary protected status recipients in the United States as well. Many of you probably are aware that this administration also terminated temporary protected status for most of the countries that currently have that status. The TPS was extended for El Salvador a couple weeks ago for 1 more year, but this bill will also help protect those individuals. And then I'm not going to go into DAD because it will take too much of our time, but it will also address individuals with DAD in the U.S. So I'm going to skip some of this content. One of the unique attributes is there's some differences in terms of whether we're talking about crimes involving moral turpitude, so the nature and the type of crime. It's spelled out a little bit more specifically in the American Dream and Promise Act, but something that was really interesting to me is that this bill will also allow for expungements. So to date and throughout our history, expunging criminal records has no impact on immigration benefits. So the federal government looks right through those, but these bills seem to indicate that if a criminal conviction is expunged, that would serve as establishing the good moral character. So we'll have to wait and see what happens once these bills are passed. Okay, I'm not going to repeat this information here. Like I said, you can access the PowerPoint and the handout that we created on your toolbar under handouts. Hopefully you see them there. We will also be sending out a link with the PowerPoint copy so you can read this at your leisure. And then again, both for the American Dream and Promise Act and for the DREAM Act of 2019, once you've gotten your lawful permanent resident status and have had that for 5 years, every individual will have the opportunity to apply to become a U.S. citizen through the normal process, just like everyone else. The other unique attributes of the American Dream and Promise Act that I think are significant is that those of us that are in California are used to what we call AB 540, a piece of legislation that was passed that allows students, regardless of their immigration status, to pay in-state tuition. So those of you from California will understand that basically part of this bill is allowing what we know as AB 540 to be national. So that means that states will be able to allow individuals with conditional permanent residence to pay in-state tuition. And so they'll get those benefits and not having to pay, international student rates for their college courses. The other significant attribute of this bill is that it would also allow individuals with a conditional permanent residence status to receive federal financial aid. And that includes federal student loans and work study programs, and for them to be able to obtain professional, commercial, and business licenses. One of my personal kind of concerns with the potential termination of DACA is that there have been so many students because they have the ability to work that have taken out a significant amount of private loans, and they've succeeded in terms of graduating. They have their degrees, and maybe they've continued their education to secure a professional license. Well, that debt does not go away with the end of DACA. And so it's going to be very difficult for those students to be able to repay those student loans or to continue their education when they don't have the ability to legally work in the United States any longer. So I'm kind of concerned about what impact that's going to have on our students and their ability to continue their education. And many of them may be forced to drop out. But again, there's not going to be loan forgiveness for those that have already accumulated debt up until the point that they're forced to stop. The other benefit of this legislation that does not exist in the DREAM Act is that it would allow that DACA recipients who were deported or who voluntarily departed from the United States on or after January 20th, 2017, they could apply for conditional permanent residence abroad, which I think is pretty incredible. So for whatever the reason may be, if they meet the requirements, they would be eligible to apply. And again, at any point in time, I can't emphasize the importance and the significance of criminal convictions. So whether you're undocumented, whether you have DACA or not, if you commit any crime, the impact on your ability to access immigration benefits or to renew any benefits you might currently have is significant. And I can't emphasize that enough. People don't understand, in certain circumstances, we get clients here in our office that come, say, oh, well, the only conviction I have is a DUI. So whenever anyone comes with criminal convictions, regardless of whether the state calls it a misdemeanor or a felony, we always have to evaluate the conviction in the language of the statute under our federal immigration laws. And I will tell you that I have had a case in federal immigration court where the government has accused my client with the DUI of attempted murder because they believe that someone could have been killed. So it is not something to be taken lightly before applying for any benefit, whether it's conditional permanent resident, whether it's a DACA renewal. If you have criminal convictions, it's extremely important that you seek legal consultation immediately because the repercussions are very, very serious. In fact, not to sidetrack too much, but there was a Supreme Court decision earlier this year that is allowing the federal government to detain individuals for their criminal history. So they've already paid for, their sentencing under the criminal matter, but if they are undocumented and committed any crime in the past, the Supreme Court decision essentially allows the federal government to apprehend them and detain them, and they are subject to mandatory detention. So it's no joke, and it's not something to play around with because I would really hate for someone to submit an application when there's problems with their history before getting them resolved and end up being in custody and not eligible for bond. So it's very, very serious. So where are we now with regards to these pieces of legislation? So as I mentioned before, on June 4th, the American Dream and Promise Act did pass the House by a 237 to 187 vote, and we're now waiting for the Senate to take up the bill and vote on it. So what we really want to do with H.R. 6 is we want to be communicating with our state senators and encouraging them to support that particular bill. With regards to the 2 DREAM Act, the Senate Bill 874 is still pending in the Senate, and HR 2820 is still pending in the House. So you're going to want to contact your senators both about HR 6 and Senate Bill 874, and you're going to want to talk to your congressional representative in the House regarding HR 2820. All right, so what can you do now, right? So I feel like we've kind of hit the spectrum of different possibilities, what's on the horizon, where we can kind of focus our time and energy. I've talked about some of these points previously in terms of please don't wait for legislation to actually pass. There are things that you could and should be doing now to ensure your eligibility in hopes that Congress does pass some decent legislation. As far as DACA renewals, I know this is probably the #1 question for our DACA recipients is, when should I renew my application? So like I said before, you absolutely should renew your application if you are within the 150-day period advance of your expiration date of your work permit. Okay, do not delay. I'm like serious. On the 150th day is when you're going to want to file that application, because again, we don't know when the Supreme Court is going to issue its decision, and we don't know exactly what the consequence is going to be from that decision. So the sooner you can get your application in, hopefully the sooner it gets adjudicated, and hopefully they don't try to recall, work authorizations, which they can, and they've done so in the past in other circumstances. But my hope is that those that have it will continue to be able to use it, and so that will preserve at least 2 years of work authorization. Now, the question usually comes is, well, what if mine, doesn't expire until June of 2020? We're well beyond, the 150 days. What I can tell you is our recent experience has been that DACA recipients have been successful in renewing their DACA applications early. The downside of that is it may cut short the 2 years, so they're not going to tag on from the expiration date of your previous application and go 2 years from that date. Basically what they do is they just adjudicate it at the time that you file it, and then you'll just get 2 years from the date that it is approved. We have heard, like I mentioned at the beginning, of 2 cases, and only 2 cases, where the individual's applications were denied because they filed too soon. So I can only say I can explain what the risks are, the pros and cons. I think it's really up to you whether you want to potentially lose the $495. There's no other, negative consequence that could result from applying too early, but you could potentially lose your filing fee because they may adjudicate the application and simply deny it. And then you would know that you would just have to refile at the 150 days. I wish I could say that, immigration processes and submitting applications is a science. I would say it's more of a human art full of error, and it really depends on which office and the officers and how they adjudicate the cases. Sometimes we have similarly situated people and we end up with different results. So there's no law or regulation I can cite that entitles you to renew sooner than the 150 days, but the practice and policy we know for certain is within the 150-day period you can renew your DACA application. What else can you do? You should explore other options. Right now is the time. If any of your circumstances have changed, if you've married a U.S. citizen or a lawful permanent resident, please consider speaking with a accredited representative for an organization that is accredited by the Department of Justice or by an immigration attorney, an experienced immigration attorney, to find out what are your options. Like I said, if you didn't accumulate unlawful presence and you're married to a U.S. citizen, if you didn't get advanced parole, you may not be able to adjust status here in the United States, but you still will be able to go through the consular process without violating certain bars that you otherwise would have triggered if you hadn't had DACA. Some people have been able to get their green cards. We have a number of our clients who are now green card holders because of either previously filed family-based petitions, they traveled on advanced parole, they lawfully entered because they're now married. So if you're married or have any other family-based petition previously filed, this is the time. I know some of you have been deterred because of costs. And it is expensive. I'm not going to, joke. To apply for adjustment of status in a petition here in the United States, it's almost $2,000. And that's just the government fees. And if you're going through the consular process and you need a waiver, we're talking, $5, $6, $7,000. So it is a lot of money, but I can't emphasize that time is of the essence. That you may actually want to borrow, gather that money to be able to secure your future here in the United States on a permanent basis, rather than just kind of wait and see what happens with DACA and then lose that protection that DACA offers in terms of not accumulating unlawful presence. There's options like VAWA and the U visa. If you've ever been a victim of any violent crime, includes domestic violence, you're married to a U.S. citizen or not, or a lawful permanent resident, those are two potential options for legalization that you may want to speak with someone about, so you can see if this may be an opportunity for you to be able to apply for your green card. There's also a program called Parole in Place, also known as PIP. If you have anyone in your immediate family who's serving or who has served in the U.S. Armed Forces, you may be eligible for PIP to get parole and to be able to legalize your status in the United States. So these are just 4 potential options that I want you to be aware of. So don't give up hope. Please speak with someone if you haven't already. Have them evaluate and assess your case to determine if you're currently eligible for any legalization opportunities that may be out there. Other steps to take, we got questions quite a bit from faculty, from administrators, from high school teachers that basically want to know what can they do to support these dreamers, to support the DACA recipients. I think it's really important that you're educated, that you stay abreast of the changes in the law, be engaged, contacting, emailing, calling, voicing your opinion to your congressional representative, both in the Senate and in the House. Encourage and work with your students, with your family members, whoever it is that you care about that is in this kind of unpredictable, uncertain future right now. Encourage them to have a plan. Make sure they can meet the basic requirements, whether it's to their education or their English language or their understanding of American history, and encourage them not to wait. Help them to organize their documents, to gather their documents, provide them whatever support that they need to ensure that they're aware of what their options are, that they're prepared, that they have a plan, and that they're engaged. The one thing that I do get asked quite a bit is that there's a misconception that people believe that they need to be a U.S. citizen in order to communicate with their congressional representative. You have to be a U.S. citizen to vote. But as far as Congress is concerned, if you pay taxes, and anyone that is alive pays taxes, whether you go to McDonald's or shop or pay taxes because of your work, you are a constituent of their district, and they are really have a responsibility to their constituents, regardless if they're U.S. citizens, lawful permanent residents, undocumented individuals, or people in some other status. But people get really nervous because they call and the congressional staff may ask for that person's address. They're not going to ask about your immigration status. They're not going to, send ICE after everyone. The only reason that they ask for someone's address is they want to verify that you do in fact live in their district, that you're not coming from Tennessee or Kentucky or New York or Florida and trying to influence their vote. So really, there's no excuse, regardless of your status. I think everyone really needs to collectively be engaging Congress and being in action, whether calling, emailing, or visiting. In the PowerPoint, you'll see that there's a list of resources that we have found very useful and helpful. And so you can access some of those resources directly at the national nonprofits that are listed there. And here I'm going to take a few minutes just to answer some questions, and I want to make sure that I can see everyone's questions here. So let me see. Okay, we talked a lot about already in terms of the advice that I would have for DACA, for individuals whose DACA expires mid to late 2020. Again, you could apply now. The risk is that you could potentially lose the $495. Okay, the only difference between a conditional permanent residence versus a regular, this is really hard for me to see. Okay, here we go. Okay, the only difference between a conditional permanent resident status versus a regular permanent resident status seems 8 years versus 10 years status length. Is that right? No, the requirements are actually different. So if you look more closely at the requirements, the permanent resident requires a little bit more. So whereas, the conditional permanent resident, it just says, GED, or you could even be pursuing your GAD as that should be sufficient. To get the permanent resident, you do actually have to have completed 2 years towards your bachelor's or already have your GED or successfully graduated from high school. So there are some slight differences between the two. So you can go back in terms of reviewing what those requirements are. What if a DACA recipient lets his or her application lapse? It depends on how long you've let it lapse. We've been successful in renewing DACAs for individuals whose DACA status is lapsed. It's a little bit more difficult, but in my opinion, it's still worth speaking to someone to assist you in getting that renewed. I can't say that everyone is eligible, but yes, it is possible to still renew a DACA application even if you've let it lapse. Many people have been too scared to renew, not knowing it's going to happen. I totally get it. I get that there was a tremendous amount of fear and people had legitimate reasons, right, not to renew their DACA application. However, you may wish to do that because I do believe having DACA is better than having nothing. The other thing I want to kind of just give in terms of perspective is, people are worried. Like if DACA gets terminated, the government has, right, their contact information. It has their address. It has all this information that they were required to submit as a part of the application, and people are worried that the day that DACA is terminated, that ICE is going to come knocking on their door. The only thing I can say to that is this: practically speaking, the U.S. government does not have the human resources, the capacity to apprehend, deport, or detain over 11 million people in the United States. Every administration has its priorities. This administration, similar to the previous administrations, are really focusing on individuals with criminal convictions, individuals that have deportation orders or removal orders, individuals that have been apprehended at the border and they came back unlawfully. So they have to focus their resources. So yes, you're right. They do have your information, but as a practical matter, it is very unlikely that the government is going to be able to apprehend the large number of people that are in the U.S. without legal status. So it's just a practical situation. Somebody asked me, can I repeat that? You said immigration is not a science. It is more like a human art piece creation with a lot of inconsistencies. I mean, it's true. Immigration, the adjudication of applications, it is not a science. I really wish there was a very specific formula that we could guarantee an outcome, but we can't. It's really, it's a human art form, and it's wrought with prejudice and error and differences of opinion. We have the law, we have regulations. There's things that those of us that practice in this area can fall back on and advocate, very strongly for our clients. But the bottom line is that we're working probably 5 times as hard as we used to for basic outcomes because of the inconsistencies, because of the mistakes or the errors, because of the challenges that just the bureaucracy creates just by the mere fact that it's a bureaucracy. So, like I said, we have similarly situated people that end up with different outcomes. What can schools, colleges, and universities do to help undocumented students? We do a lot of presentations in the community. I think to the extent that you have a student body that has a need for good information in terms of know your rights, I think every college student needs to know that they're safe and that their information is secure. So we do trainings for staff, faculty, campus security, but as well as college students so they know what to do should ICE come on their campus, should ICE visit. Faculty needs to know, what their rights are as well, because they are tasked with protecting the privacy, safety, security of their student body. So to the extent that the schools can host presentations, both for the faculty, staff, and college, administrators and their students. The content's slightly different. I think the more you can make that available, the more safe and secure students will feel. I know a lot of college campuses here in California were able to apply for some state funding that they're now offering legal consultations for their students free of charge. They were able to get those grants. So to the extent that those grant opportunities are available, I would really encourage schools, colleges, universities to apply for those grant funds so that you can make that valuable resource available to your students at no charge. If you are now married to a U.S. citizen, have DACA, but got DACA at 23 years old, meaning you've already accrued unlawful status, there are process to naturalize without the time bar. So I would say it depends, right? So we would have to look at whether there's an avenue to pursue where you can legalize your status here in the United States. That's always the first goal, is to avoid people from having to leave. However, let's say you're still subject to consular process and you're going to have to leave. There is what's called an I-601A waiver that allows individuals who are married to U.S. citizens or lawful permanent residents that they can apply for in advance of their departure, and it forgives their unlawful entry and the accumulation of unlawful presence. You should not depart the United States under any circumstances unless you have that waiver approved and you've been given kind of guidance and consultation from a competent immigration attorney. But yes, there are opportunities and ways in which people can legalize their status, even if they accumulated unlawful presence because they were over 18 when they received DACA. Okay, it says, is there any danger in traveling domestically right now? Is the real ID an issue without status? So it's just a danger in general if you're undocumented, right? You could be at risk. We're here in Orange County. It's a risk people driving down to San Diego because we know in San Clemente there's a CBP checkpoint. So there's never kind of that safety and security, again, unless you've got DACA. If you've got DACA right now, as long as DACA is intact, you have the protection from deportation. So you're okay. I wouldn't worry if you have DACA. Things may change if, again, there's no more DACA, then you're going to be just as vulnerable as any other undocumented individual. What is submitted? Oh, the Real ID. I didn't talk about that. So the Real ID has its own, set of requirements, and it's really, they have the alternative ID if you don't qualify for the Real ID, which is the same as what we know here in California as our AB60 driver's license. So you don't have to get the Real ID, but if you do intend to travel domestically and want to use your driver's license or your California ID for purposes of travel, then by October 2020, you do need to have that Real ID. But you can continue to use a passport for travel purposes, so you don't have to get the Real ID. Would a submitted community college application qualify as admitted to college? California Community College auto admit. So I think you're going to need to demonstrate that you've actually registered, enrolled, and you've attended school, not just being admitted. I don't know that that's going to be sufficient for purposes of applying for permanent residency under the pending legislation. All right, I have 3 more questions. I realize that we're 3 minutes over. I will wrap these up in the next 3 minutes. I want to honor everyone's time. The last 3 questions I see here are DACA dreamers and their families vulnerable to ICE detainment? Who is vulnerable? Is this relevant to DACA dreamer recipients? So again, DACA is protected, right? That's one of the benefits of DACA. Are their families at risk? Yes and no. So anyone who's in undocumented status is at risk of being apprehended at any point in time that they have contact with ICE. Or law enforcement that may cooperate with ICE. Here in California, we have state laws that protect immigrants in the state, but I know in many states across our country that's not the case, and there's a lot of cooperation going on. So what's important to know is that everyone, regardless of your legal status, has the right to remain silent. Again, I would advise everyone to consult with an immigration attorney for 2 reasons. One is to make sure you're aware that there's no opportunities that are options for you to legalize your status. And secondly, and perhaps more importantly, is that someone can explain what risks, if any, you may have of being apprehended. So if you have prior removal orders, if you have immigration violations, if you've been, deported and you've come back, things of that, you are going to be at a higher risk than someone who just entered the U.S. unlawfully and is kind of kept under the radar, has no criminal conviction. So I would say the degree of the risk depends on the circumstances, but again, nobody is protected unless they have the deferred action or legal status, and DACA being a version of deferred action. How do you encourage individuals to obtain legal help when legal costs discourage them? I will tell you, one of the beauties of this administration is that it has forced so many of us to collaborate and work together and pool our resources together. So there are options. What we can do is when we send out the link with the PowerPoint presentation and with the recorded webinar, we will also send the link for locating Department of Justice accredited organizations in your area. So I would say go there first. Avoid notaries, avoid immigration consultants. If the person is not licensed to practice law and they're not an accredited organization, I would say you need to proceed with caution. But there are affordable options out there depending on where you live in your community in terms of the number of resources that may be available, but I would look into those resources first. And there's lots of scholarships, and I know several organizations here locally, and some colleges and universities, another way that they choose to use their funds, will pay the legal costs for DACA renewals, for example. So if the universities and colleges have those resources and can I help alleviate that burden for their students, I say more power to them. So I don't want you to be discouraged from seeking legal assistance or help because of costs. I think that there are options out there that you may be able to find where you live. And again, we want to be here as a resource to you. You can see on the PowerPoint our contact information. If you need help or guidance in terms of a consultation, we can do it Skype, we can do it telephonic. If you need a accredited organization, like I said, we'll send out that list. But we really do try to point people in the right direction. I get that not everyone can afford a lawyer. Our office's philosophy, if they don't need a lawyer and we know of resources that can handle their case far more or less expensive, then we will direct them to those resources. All right, and the last and final question, which is a great question to end with, is will this webinar recording be available for download so I can review it later? Yes, and everyone that registered for this webinar will receive a link for that recorded webinar. We'll also post it, I believe, on our YouTube channel, and we'll send it out via our newsletter as well to those of you that are signed up for our e-newsletter. So you have there our handles for Facebook, Instagram, and Twitter. I want to thank you for taking the time out of your busy day to join us today. I apologize for going 7 minutes early, but again, it's our pleasure to serve you. If you're interested, if you're local, in having us come and speak at your community, college, university, or organization, feel free to contact me, and we're happy, like I said, to serve you. So again, thank you very much, and have a great rest of the afternoon and a great weekend. Thank you.